Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the wild weekend in Ontario, where Premier Ford announced new sweeping police powers, powers that, in the view of many legal experts, were plainly unconstitutional. In the face of swift reaction from both advocacy groups and the public at large, the Premier repealed those powers within about 24 hours. What exactly were those powers? Where is the law now? And what was the constitutional problem that had everyone so upset? How and why would the government enact police powers that they ought to have known were unconstitutional? The charity that I work for, the Canadian Constitution Foundation, was one of the organizations that swiftly condemned these enhanced police powers and announced we were planning a constitutional challenge. The Civil Liberties Association, the Canadian Civil Liberties Association, is another. Today, we'll be speaking to Abby Deshman from the CCLA, as well as criminal lawyers Karima Saad and Rachel Lichtman. Thank you all so much for joining me today. Abby, I'd like to start with you. Can you tell me what this new police power that the Premier enacted and then repealed actually involved?
Yeah, so it was a very, very broad police power that did give the police, for the short time it was enacted, the authority to stop anyone, to detain them, to ask them questions to determine whether they were violating Ontario's stay-at-home order, which is a really broad and complicated order with lots of exceptions. So those would have been very intrusive questions. It also authorized police to pull over cars, detain people in their cars, and demand they provide answers to those questions if they were in their cars as well. So really arbitrary police powers. You didn't have to suspect that anyone was doing anything wrong or violating the law for it to be detained and questioned.
So Rachel, at a high level, what were your immediate concerns with those powers?
So those powers breach multiple different sections of the Charter. So to name them off, it would be Section 7, 8, 9, 10, and Section 13 of the Charter. Section 7 is your right to life, liberty, and security of the person. Section 8 is your right to be free from unreasonable search and seizure. That search and seizure being, you would have to produce some kind of identification or something to prove where you live and to justify where you are at the time. Section 9 is the right to be free from arbitrary detention. Section 10 is the right to be informed that you're being detained and to be given a right to counsel. And then Section 13 is an accused right not to incriminate themselves, which is also known as the right to silence. And by definition, these police stops would be saying to people, okay, you're out. Now justify to me why you can be out, which is in itself problematic because you're basically stopping someone and saying, you're guilty. Prove to me that you're innocent.
Great overview. Thank you so much. Karima, same question to you. What was it that really troubled you about these police powers?
I would echo what Rachel said, and I would add that historically, when it comes to the enforcement of police powers, there is pretty broad discretion, and we see that discretion time and time again disproportionately used against marginalized communities, be that low-income communities, racialized communities. And so there was a very real concern that the people living in so-called hotspot areas who are most likely perhaps to be essential workers would also face this added burden of police interactions and having to justify their existence outside.
So Rachel, the Premier has now changed these powers. He changed them within about 24 hours. Can you tell our viewers what the new police powers are under the revised regulation?
Yeah, so under the new powers, the police have to have reasonable and probable grounds to believe that people are participating in some kind of organized event or that they're socially gathering together.
And reasonable and probable grounds were not explicitly required under the previous order that was repealed. Is that correct?
That's correct. Before, the police could just stop anyone, anywhere, at any time while they're in their vehicle or just walking on the street and start questioning them.
Now, in about 20 seconds, Abby, just briefly, how does the CCLA feel about the revised rule?
I mean, they're much narrower in scope, and it's reasonable suspicion. So it's a lower standard than reasonable and probable grounds, and people are still going to be stopped. Do still have to provide answers. So there are still issues, and we are very worried about, as Karima said, how this is going to impact the people that live in racialized communities that are already subject to police powers disproportionately.
Let's get back into it after this commercial break. Welcome back to Canadian Justice, where we're talking about the Ontario government's enhancement and then repeal of broad police powers to enforce the stay-at-home order. Abby, at the Canadian Constitution Foundation, where I work, we spent Friday night and Saturday morning working with council to prepare a challenge to these powers, and I understand that the CCLA was doing the same. Can you tell me a little bit about what exactly you guys were planning on challenging?
Yeah, absolutely. So, I mean, it's all the issues that Rachel and Karima raised before the break. So, people's general liberty interests under the Charter, right to be free from arbitrary search and seizure, right to be free from arbitrary detention. I mean, the original powers that were proposed were the very definition of arbitrary detention. The police didn't need to have any evidence or reason to stop you and pull you over. And we were also focused on Section 15. That's the equality section of the Charter, and specifically because of the people who are disproportionately subject to police stops and questions now, and the people that are disproportionately impacted by COVID. We're particularly worried about the unequal impacts that these powers would have on racialized communities and others who are over-policed.
Now, Karima, one of the things that I've actually read since all of this happened and that shocked me personally the most was that Cabinet was actually told by the Attorney General, Doug Downey, that this police power may be unconstitutional. What does it tell you that we learned that they were warned and then decided to proceed anyway?
I think it's consistent with the Premier's response to virtually every aspect of the pandemic, where he's given expert advice and chooses to go in a different direction. And what forces are propelling him in those directions remains to be seen. But I find that very concerning and upsetting. And I think that the people of Ontario should be upset as well.
Abby, same question to you. What does it tell you that Cabinet was warned and then acted to create these unconstitutional measures anyway?
Well, it's deeply disturbing. I mean, we should not have parts of our democratic government simply ignoring the Constitution. I mean, these, from our view and in many other people's views, are just clearly unconstitutional. So, it is deeply concerning that would be raised and then they would go ahead with this, and also signals to me some kind of breakdown of the internal processes of government, which are supposed to have really thorough checks in place to make sure that the government doesn't enact unconstitutional powers, that, these things are really well vetted before they come to the cabinet table. And it really seems like that was not happening before very, very crucial decisions were being made in that room.
Rachel, I want to follow up with you on something that Abby and Karima had both mentioned earlier, which is the comparison that's been made between these police powers that were enacted and repealed and the policy of carding. Can you explain what carding is and why it was banned and why this is so similar?
Of course. So it was banned in 2017, and it's actually shocking that it even went on for that long. And carding was, again, arbitrarily stopping anyone the police wanted for absolutely no reason, looking at their ID, taking their ID, asking them questions, and also to really add like salt to the wound, they would keep that information on record. So a completely innocent person just walking down the street could have their information kept in a system, in a police system, for absolutely no reason when they've done nothing wrong. So, it also had, as Karima and Abby already touched on, it also had the effect of really disproportionately affecting the African American community and the Indigenous peoples community. So it was really an unfair, completely shocking policy and banned in 2017. And this is similar to that because you're stopped for absolutely no reason. There wasn't any kind of expansion for it, never really expanded on what they would do with the information, the police officers, what they could and couldn't do with the information that they would gather from people. So that's concerning as well. But they're definitely very similar policies. And I'm very happy that they were repealed very quickly.
Abby, one of the concerns that I've heard, or comments, I guess, is that if the stay-at-home order itself is valid, it's valid to enforce the stay-at-home order. Can you comment on that specifically? I mean, if we have a stay-at-home order, why can't the police just stop people?
Sure. I mean, so I have two answers to that. First, it is valid to enforce it within the bounds of the Constitution, right? We have a Constitution that is there to protect individuals' rights when they are dealing with government actors who have an enormous amount of authority and power. And those constitutional limits have to be respected. So yes, we have police, we have bylaw officers. They are there to enforce laws. They must do so within constitutional limits.
Abby, I'm going to let you finish the second part of that thought just when we come back from these commercial messages. Welcome back to Canadian Justice. I'm Christine Van Gyn, and we're talking about Ontario's stay-at-home order and police powers. Abby, I want to let you finish your thought on that. If we have a stay-at-home order, why shouldn't the police be able to enforce that stay-at-home order?
Thanks. So the first answer was the Constitution. They can within bounds. But the second answer is more of a policy and public health answer, really. You know, the stay-at-home order is very broad and very complicated. And we're facing a public health crisis. We are not facing a public order crisis. The vast majority of people are doing their best to follow public health advice and keep themselves, their families, and their communities safe. And what we need, what communities need, what essential workers need are supports and services and all of the robust evidence-based public health responses that scientific advisors are suggesting. What prejudices the public health response is when you have police on the corners stopping people, asking them why they're outside, which we know is the safest place to be in this pandemic, and inquiring after very minute details to try and figure out whether they are allowed to be outside or not. It's just not a productive way to try and make it through this pandemic.
So speaking of those reasons you can be outside your house, I think we have this stay-at-home order with all these exceptions. Karima, can you explain what those exceptions are? I mean, what are some of the reasons people are allowed to leave their home under the stay-at-home order?
It's a pretty wide range of exceptions, and they're all set out in the regulation. But some examples include work, childcare, school when school is in session. People are allowed to go out to obtain goods and services. There are provisions about assisting others. So that might mean delivering goods or services to someone, taking a child from one parent's house to the next. Health, safety, legal purposes if someone's in imminent danger, for example, from some kind of abuse or needing to seek emergency assistance, but also exercising, provided one is in a permitted amenity or moving around outside. And some of the other reasons, moving, or if someone is making arrangements to sell a home, there are certain limited gatherings that are permitted. And if you have pets and are doing something with respect to your pets, that's allowed as well. And none of the order applies to people who are homeless.
I mean, I think people should familiarize themselves with some of these exceptions just so that they're aware of what the law is in Ontario, because there has been so much confusion about it. Now, Rachel, we have been talking a lot about these terms, reasonable suspicion and reasonable and probable grounds. Can you explain for our listeners what those terms actually mean?
Sure. So I think the best way to explain them is through examples. So if you would see, two adults and 2 or 3 kids outside, that would not be a reasonable or probable grounds or suspicion to think that those people are breaking the stay-at-home rule. But if an officer would see about 4 or 5 adults and 7 children, that would be an example of where there would be reasonable or probable suspicions that there are more than one household gathering together. Now, it may not be. It could be that those people are in a household together, but that is reasonable to suspect that it's more than one household because it's more than 2 parents and it's more than usually what one family has for the amount of children. So that's how I can go about it. I think that word probable was added in there to make it sound pretty, because I think reasonable is really what they're going for and kind of covers everything. But I think the government and specifically Ford was trying to say, oh, look, we're really fixing our mistake. It's not just reasonable, it's reasonable and probable, but that word added in there, I don't really think adds so much.
Abby, I want to ask you about the police response to this. We saw police from across the province announcing that they weren't going to be conducting random stops. What's your reaction to that?
Well, I mean, I welcomed the news, and I was pleasantly surprised. I don't know of any other time when the police have been extended new legal power and so quickly have come out to say that they will not be using it. And I think it made a big difference, at least in terms of how quickly the government walked these powers back. I do think that had an impact. I remain concerned about how the police are using their existing powers, right? So we now have seen Toronto police planning on forming dedicated squads in each of their divisions to go out and police COVID-related orders. We've heard of Hamilton bylaw officers standing at the top or bottom of the escarpment stairs and trying to figure out, based on dress, who is doing essential travel and who's using the stairs for recreation. We've heard of people being stopped. And so it remains a concern what the police will be doing.
We're going to just go to commercial, and then we will get back into it after this break. Welcome back to Canadian Justice. I'm Christine Van Gyn, and we're talking about Ontario's stay-at-home order and police powers. Now, I want to do some questions with you guys about what our rights are when police stop us. And Karima, I'd like to start with you. What do you recommend people do if police stop them on the street and ask why you're outside your home?
I mean, first and foremost, people should keep safety in mind. So I kind of preface with that. If one is able to, you might inquire with the officer, what are your reasonable and probable grounds for stopping me? If that feels like it might be too adversarial, what the regulation requires is that people provide information to show that they're in compliance with the order. So having sort of a clear purpose that corresponds to the regulation, and leaving it at that, not over providing information, and at the end of it, asking whether you're detained or free to go, because at that point, the officer will need to make a decision whether they are detaining you, in which case your right to counsel is triggered. And there are hotlines, including from the Black Legal Action Center that people can call. And if they aren't detaining you, then you're free to go, and I would end that interaction.
Really great advice, Karina. Thank you. Abby, the new regulation doesn't specifically talk about vehicle stops now, but what do you do if the police do stop your vehicle, under the Highway Traffic Act for speeding or something, and they then ask why you're outside your house? What would you recommend people to say?
Yeah, so, there is no obligation to provide information about why you're outside your house, right? Right now, the law only says you have to provide information related to illegal gatherings. So, if you feel safe, if you are able to, the police will be able, they have broad authority to pull you over, to check your driver's license, and make sure that you are a registered driver. If they ask other questions and you don't think they relate to, COVID gathering laws, you don't have to answer those. And if you feel safe, you should say, I don't want to provide any more information. And then you should be let on your way.
Really good advice. Thank you, Abby. Now, Rachel, there are a lot of amenities that are closed right now, like basketball courts, skate parks, or picnic benches. Playgrounds are open now, but those other ones are still closed. So can police stop you if you're using one of those closed amenities?
They can, and not for social gatherings, so to speak, because you can be using them alone, but it was part of the stay-at-home order that those amenities are closed. So the police can stop you and also ticket you for breaching the stay-at-home order because those amenities are closed. And even if in your area some of those amenities haven't been closed off yet, or there's no tape over them, it is still in the order and part of the regulations that you're not allowed to use them. So even if you are using them alone, you can be ticketed for using those amenities.
Abby, Karima, Rachel, thank you so much, all of you, for your time today and for all of your amazing advocacy. This was a really crazy weekend in Ontario. I'm really horrified by what the government did in acting a knowingly unconstitutional law, but I'm happy that it has now been repealed. I want to thank you so much for both your advocacy and your time appearing on my show today, and good luck. Stay safe out there, guys.
Thanks, you too.
We've heard today about the Ontario Premier's decision to enact and then immediately repeal unconstitutional police powers to enforce the stay-at-home order. New legislation and regulations go through legal risk assessment as standard practice, and Cabinet would have almost certainly had a legal risk assessment in front of them for discussion before deciding to approve the enhanced police powers. And we also now know that the Attorney General raised these concerns directly at Cabinet. You know, while we're never going to know what that risk assessment contained, it's a virtual certainty that it raised some of the same concerns laid out by the Canadian Constitution Foundation and the Canadian Civil Liberties Association. The willingness of the Ford government to proceed with a bad, illegal law that they were aware is flawed was likely at least partly driven by their awareness that they could get away with it because the courts would not be able to stop them in time. Politicians who knowingly enact illegal laws deserve condemnation and have lost moral authority. I'm Christine Van Gyn, and remember, a freer Canada starts with you.